President Trump and his 34 convictions that he had for the hush money thing. And I know when I did the story, just kind of talking about it, somebody in the comments blasting me was like, he wasn't convicted. A judge has to determine a conviction. And I don't even know why I engaged it with a back and forth over what a conviction is, because they clearly didn't know. And I'm pretty sure I know what a conviction is. But it looks like it's been postponed indefinitely. So we're going to tune in, watch this news story about it being postponed indefinitely. They actually have an attorney on the show who does a bit of a legal analysis, but I'm gonna be honest, I don't know if they actually read the opinion in that Supreme Court case that related to the president's immunity from criminal actions and how it relates to whether or not his actions were an official act, because they got the analysis right, but they missed the most important part of the analysis. So let's go ahead, jump in, and dive in and talk about it. But I had everything set up already.
But first, the judge overseeing Donald Trump's New York criminal case has postponed the president-elect's sentencing indefinitely. Trump was convicted back in May on 34 counts of falsifying business records related to hush money payments made to adult film actress Stormy Daniels while he was running for president the first time. Trump was set to face sentencing this month, but Judge Juan Merchan agreed to wait to allow Trump's legal team to argue for a full dismissal of the case. CBS News legal contributor and Loyola Law School professor Jessica Levinson is back with more. So, Jessica, talk to us about the arguments that Trump's lawyers will be making for.
Real quick, if I was that judge, I mean, I can understand. I wouldn't say if I was that judge, but I can understand what judge would be the one to go through with the sentencing of the president-elect who's going to take over office in the next month and some change. I don't know. I think that's crazy. I think anyone who didn't see this coming or think it's unfair is just being completely unrealistic, because I think any president in that position would exercise the authority the court gave him. But let's check out this analysis. Then we're going to turn briefly to the U.S. Supreme Court's decision, and we're going to talk about a big point that they missed.
Jessica, talk to us about the arguments that Trump's lawyers will be making for a dismissal.
So the arguments they'll be making are essentially two tracks here. One depends on the Supreme Court's decision in that big immunity case, where very briefly the Supreme Court said when it comes to presidents and former presidents, there's immunity from criminal prosecution for official acts. So
I think everybody would generally agree that that makes sense. If I'm the commander in chief, I'm performing an official act. That official act has some criminal exposure. I think that's something that if you ask most people, should the president be immune from official acts? I don't know. I don't think most people would argue with that. So that was point number one of the Supreme Court's opinion. Presidents are immune from potential criminal exposure as long as their acts are official acts.
There's immunity from criminal prosecution for official acts. So question number one really is, are any of the acts that form the basis of this conviction official acts? I think because of the facts of this case, the answer is probably no. Question number two is, can we even sentence in this case because we have not a normal criminal defendant, but we have the president-elect? And that's been one of the other arguments that President Trump's team has brought forward. Then finally, Lana, the question really becomes, if we can move forward with sentencing, when will it happen? Will it happen before January 20th, before the inauguration, or would it be postponed until after the entire presidential administration? I just want to remind everybody, Judge Merchan, the first judge in the country to ever have to confront these questions.
Yeah, it is entirely
the first judge in the country to determine if the president should actually, he was already convicted, should he actually be sentenced? Or is it lawful in light of these new Supreme Court rulings? I mean, I just personally don't think nobody's going to want that smoke. I think everybody's going to take that football and punt that thing 60 yards and steer clear away from it.
Entirely unprecedented. And we can dig into that some more, but I want you to lay out for our viewers what prosecutors are arguing, because they've already said that they're going to oppose any efforts to dismiss the case entirely. Do we expect this legal fight to continue into Trump's time in the White House?
Well, in terms of the appeals, that is absolutely possible, because we know that Judge Merchan at some point will have to make a decision about what, Juana, you and I just talked about, which is, what about immunity? What about whether or not you can move forward and sentence somebody who is the president-elect of the United States? So there are some legal questions here, which, as we said, are really matters of first impression. You can absolutely believe that the losing party could appeal those up. And it's very difficult to see how all of the appeals would be done before January 20th. Again, we've never been here before where there's a pending criminal case against a sitting president. But it is important for people to know we have a jury verdict in this case. We don't have a lot of legal guideposts, but one thing I would tell people is the criminal justice system likes finality, and they like to respect jury verdicts. So I think what we're going to be looking at is maybe fights more realistically around the timing of sentencing than actually having the entire case dismissed.
So, Jessica, given that this is all without precedent, and what you said about it potentially being appealed upward, how will this ultimately be determined? Do you imagine that it's going to require the Supreme Court to further weigh in on this? And is it even possible just to delay sentencing until after the Trump administration?
Possibly.
I'll take the last question first, which is, yes, it is possible to delay sentencing. I mean, we have been here before in the sense of there are other criminal cases where judges say we're going to delay sentencing for, and sometimes it's an illness or it's medical treatment, surgery, for instance. We've never had to delay sentencing for a presidential administration, but there is a legal roadmap for something is happening and we're going to delay sentencing. Now, in terms of, you asked me great questions about, the appeals. Could this make could this case make its way all the way back to the Supreme Court? So we need a federal issue to get to the Supreme Court, and the federal
this is a
issue,
state one.
Right, great point, except that the federal issue now might be that there's a state court judge applying that immunity decision. And potentially you could see an argument that he's not applying it directly. Supreme Court, give us guidance about what you really meant when it came to this immunity decision.
And the federal issue is also, he's the president-elect. All right, Jessica Levinson, thank you.
All right, real quick. So let's talk about this real quick, because I'm gonna show y'all. Let me see. I want to pull it up before I show y'all. It's 1, 2, 3, 4, 5, 6, 7, 8. Is 8 words in the entire opinion of Trump versus the United States that was appealed to the Supreme Court that are important, that I have yet to see anybody on the news talk about. I seen one media outlet talk about it when the decision first came out. Everybody else, I'll be honest, I don't know if they read the entire opinion. I didn't read the entire opinion, but I read the analysis. I don't really care about the facts because I knew the facts. I read the analysis and I read maybe 2 of the dissents. There were 3. I read 2 of the dissents because I wanted to know what was going on. But personally, you can postpone sentencing until whenever. Somebody get in a car accident, they can't come to the sentencing. I've seen this happen. I've seen sentences postponed 1, 2, 3 years. I've just seen these type of things happen for whatever reason. 2, I'm gonna be honest, I think it's just gonna all go away. I think it's gonna be a big dismissal, in my personal opinion. I don't think any state judge wants to smoke, right or wrong, of having to be the first person to hand down and bang their gavel to a sentencing of the president in light of a new Supreme Court opinion that nobody really knows how to apply. And this state judge is supposed to be the first person to apply it and get it right. That's actually kind of crazy. But it is a strong chance it's going to go back to the Supreme Court. Let me go and look at the comments before I pull up the 8 words in the opinion that they forgot about that are the most important. Not a federal judge. Let's see. I agree. It was contrived for the sake of lawfare, not for justice. I'm saying, when you get a chance, read about this. Just in Illinois Governor J.B. Pritzker It signs in the law that allow illegal immigrants to become police officers. Bro, what? Yo, man. These oh my god, that's a whole nother. I could do a show on that for 2 hours. Oh my god, this is it's just a catastrophe what a lot of states are doing, trying to handle the migrant crisis. And it really shows a lack of leadership, creativity, and concern for the citizens on all parts, in my personal opinion. I say save it to later. That's definitely an option. Lock them up. Hey, most powerful man on the planet? Nah, I don't know if that's going to happen. Hey, I get it. Generally, I mean, when you charged with a crime and convicted of a crime by a jury of your peers, there should be a sentencing, but is a very unique situations. That's all I can say. The underlying crime has never been stated. Jury just had to pick one of three possible to legitimize the felony charges instead of expired misdemeanors or contrived. Yo, I'm gonna be honest, and I said this before. I never did a video on it, but I did say this before. That is an actual great comment, and I could tell you had your finger on the pulse of what's going on with the trial because with regard to those 34 convictions, your point is a good one. I looked at it. He actually has an amazing argument to challenge all of those convictions on appeal and actually win because of the expired misdemeanors, in my personal opinion. So it's funny because I've never seen it brought up, and honestly, I understand why. My guy just won. If I'm an attorney, I'm like, my guy just won the presidency. I don't even need to go that far if I got the Department of Justice already stating that they don't want to prosecute presidents, and I got a Supreme Court case that's favorable. But you are 100% right. He really does. As hey, whether you love him, hate him, like him, dislike him, President Trump does have a legitimate legal argument to appeal these state convictions and potentially win because the misdemeanors were expired. So, hey, shout out to you. That's a good comment. Let me go ahead. I need to stop sharing this screen and I need to pull up the case. I want to pull up the case so you all can see it. Let me get this pulled up. Share screen because I want to show y'all the 8 words that makes all of the difference. And it is on. We're gonna go to page 26. This judicial opinion is 119 pages. The courts ruled Supreme Court ruled 6-3 that the president can't be charged for criminal conduct as long as that conduct is official duty. Now, and that's right. Whether it was official duty or not, that's correct. Here's where it gets interesting because before I read it, we got to talk about this a little bit. Courts are bodies whose sole job is to find out what's going on. So the whole purpose of going to the court, when you go through the trial, pick the jury, have the witnesses, present evidence, is to find out what happened, what is the closest version to the actual truth, and let the jurors evaluate that. So in any court, the number one thing is we have to have a mechanism so we can determine what is true, what happened. And that only happens by questioning witnesses and presenting evidence. Now, I want y'all to take that into consideration when y'all see these 8 words. Don't forget he's on record asking for 11 out of the votes for some stupid reason. Everyone's just afraid of him. I mean, the most powerful person in the world. I can see why it's. I can see why a regular person would probably. I can see why a state court judge would be like, "Oh man, I don't know." Everybody ain't willing to stand on business like that. Me and my boy just had this conversation today where the question was, would you do the right thing if it meant losing your livelihood? And I was like, 98% people won't do that. 90%, 98% people won't do that. I know. I was in a job where I lost my job because I was like, nah, this is wrong, and we're gonna stand on this. And everybody I asked who was older, they was like, man, just put your head down and keep on moving. And I was like, nah, I can't do that. I can't sleep at night knowing that I'm letting the wrong thing go on. Whether they know it or not, I know it's the wrong thing. And so, but everybody's not built like that. Now let's take a look at this opinion. We can scroll down and see this is Trump versus the United States. Now remember, if it's an official act, so it's pretty much two things. If it's not an official act, the president can be charged with a crime. I think we all agree with that. If I do something that personally benefits me and it's not an official act, me trying to carry out my executive authorities, I shouldn't be able to have any type of immunity for conduct that may have criminal exposure. I think that makes sense. I think most people agree with it. The next standard is if it's an official act, presidential immunity applies, can't be charged with a crime. Now, here's the interesting part. How do we determine what's an official act? Let's say we went to trial to determine if the president's conduct was an official act. We have to do some type of fact finding. What does that mean? That means we're going to have to talk to people, put witnesses on the stand, talk about if it's not some type of executive privilege, talk about what was the nature of the conversations and the situations before and after the president made this decision that's at issue. Because we got to look at all the facts and circumstances so the court can make a determination of, okay, we've listened to the evidence and this is in fact an official conduct. But the Supreme Court, they gave the president a lot of authority. And I don't know if you all remember when this decision came out, I saw a lot of Democratic swinging news media outlets was like, oh, the Supreme Court just gave Trump unlimited power. And again, I think that shows how sometimes you got to think. They were arguing about the Supreme Court giving a decision that gave President Trump more power if he were to win. This was before the election, if he were to win. They didn't even realize that, we're in office right now. If they made a decision that gave the president power, who's the president right now? But everybody just kind of looked into the future and didn't think of how to use it. But these are the 8 words that the court did. I'm going to read this paragraph. But the 8 words are, courts may not inquire into the president's motives. Those words right there, courts may not inquire into the president's motives. If you can't inquire as to whether the president's motives or what his motives were, you can't make a determination that an act was official or unofficial. So if I'm the president, I'm going to say everything is official because you can't cross-examine witnesses or do direct examination of witnesses to find out. It says, in dividing official from unofficial conducts, court may not inquire into the president's motives. Such an inquiry would risk exposing even the most obvious instances of official conduct to judicial examination on the mere allegations of improper purpose, thereby intruding on Article 2 interest that immunity seeks to protect. It would seriously cripple the proper and effective administration of public affairs as entrusted to the executive branch of government. That's a big deal. I don't know if you all get that, but the president can't be charged with a crime for official acts. But the Supreme Court said courts can't inquire into the president's motives. That essentially means you can't inquire into whether the president's acts were official or not. So the president, if I'm the president, I'm going to always assert that everything is official. A lot of power given to the president right there. A lot of power given to the president. And one thing that, again, you say what you want to say, no matter what role you're in, you never know if you become the CEO of a company or the president of some organization, you never know the limits of your power until you push. So with this language, all it takes is a president who's willing to push to see what the limits of how far can I push the limits of my power with this court decision before somebody actually say, okay, we have to give some clarity and granularity. Now, the dissents picked up on this big time. There was a 6-3 opinion in favor of no criminal charges for the president for official acts. 3 of the dissenting opinions all said, hey, we generally agree with that. But if you don't allow a court to inquire into the president's motives, you'll never be able to determine if the president's motives were towards an official or unofficial act. So it 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 really the what you're trying to accomplish is negated because you don't give the court the authority to inquire into it. But the other side is saying, well, if the court inquires into the president motives, it intrudes on the separation of powers between the executive and the judicial branch. It's an absolute mess, honestly. I'm gonna be honest. Like, I get the opinion. I'm not a fan of this language right here. I think the general rule I could be on board with. The general rule: official acts, president can't be charged. Unofficial acts, he can be charged. But you have to be able to have a mechanism to determine what's an official act and what's an unofficial act. It can't come to me as the judge and I just look at it and say, well, that's an official act, but that's an unofficial act, without hearing evidence to determine what the motive of the commander in chief was. So I think generally I agree with it. I'm not a fan of this language because I think it's counterintuitive, and the whole purpose of court is for fact finding to determine the truth. And if you can't inquire into the person's motives, every other if someone is charged with a crime, you can always determine their motives. You can bring them on the stand and, hey, I want to look for motive and opportunity. If you got motive and opportunity, if I could prove motive and opportunity, I probably could connect your ass and line up what I need to line up to get this conviction. So it's kind of a mess. What I would like to see, honestly, rather than the charges be dismissed, I would rather see the state court in New York articulate a good federal question that allows this to go to the Supreme Court so they can provide some clarity and we can figure out what the fuck they need to do. And honestly, the Supreme Court probably gonna be like, nah, we not going. I've never seen the Supreme Court render a decision, give out a new test or standard, and then immediately say, well, let us re-explain what's going on. Normally, they'll put out a rule. The rule is kind of confusing how this is. And then some courts will say this, some courts will say this, and then they'll come back and say, okay, let us clear it up for you guys, since y'all clearly don't know what the hell we meant, and we didn't articulate it in a way to say what we meant. So that's going to be interesting. Hey, this isn't a left thing or a right thing. This is just what the justices said. And fortunately or unfortunately, depending how you look at it, 6 of the justices lean more towards the conservative side, and they are in favor of expanding the executive's power. And that's what they did big time with this opinion. So I don't know. I thought that was an interesting story to talk about. Let's go ahead and hit up some of the comments. Hey, I'm gonna be honest. I've said this same thing. I've said this exact same thing statement. Telling someone to find votes isn't indicative of telling someone to fabricate votes. And I've listened to that conversation because I was like, well, what did he say? And I listened to that conversation, and that was the first thing that I actually thought. I was like, I'm just going, hey, I call it like I see it. If he would have said something that would have been like, oh, yeah, you can't be like, hey, bro. I just like, hey, we down this many votes. You need to look and find them. See, if they did, you got to look and find them. It's just ambiguous enough where it could be argued either way. I don't think it was a knockdown thing of him asking for him, and I don't think it was a knockdown thing of him not asking for him. But I think it was ambiguous enough where it could be argued either way on either side. And I don't know if that was him being smart or he just happened to say it in a way where it could be argued either side, but it ended up working out in his favor. I'm from Indianapolis and I care about my fellow Americans in Dalton. Hey, what's going on? Hey, shout out to Indianapolis. They got some good restaurants up there. I was in Carmel. Great restaurants up there. All right. Let's see. Motive is everything, even as stated by the FBI. So I do not agree with this exemption. I agree. We on the same page, co-counsel. We on the same page. I agree with the general rule, but I'm not in favor of not being able to look at the president's motives to determine if his act was an official or unofficial one. I think that just it don't make any damn sense to me.